The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. My name is Hunter Liles, and I'm a paralegal at Liles Parker. Thank you for joining us today for a special webinar, which is presented by Liles Parker and sponsored by the Texas Association for Home Care and Hospice. Today's topic is Impact on Home Health and Hospice Agencies of the New and Modified Anti-Kickback Safe Harbors. The OIG and CMS have recently released major updated regulations for the anti-kickback and Stark statute, which revised a number of existing safe harbors and exceptions and adopted several new safe harbors that can affect home health, personal care, and hospice providers. In this webinar, attorneys Michael Cook and Robert Liles will discuss these important developments in the anti-kickback safe harbors. The presenters will provide an in-depth discussion of these changes and how providers should respond. This webinar is scheduled for 60 minutes with a Q&A session to follow. And that being said, let's get started.
Thank you. Good morning or afternoon, depending on what part of the country you're listening from. My name is Michael Cook, and I'm a partner and co-chair of the healthcare group at Liles Parker. I've been practicing healthcare law and representing healthcare-related clients in private practice since 1981 in all kinds of regulatory, enforcement, business, and health policy matters. Before that, I represented the federal regulators of the Medicare and Medicaid programs as an attorney with the General Counsel's Office of the United States Department of Health and Human Services for about 7 years, and during that time also served on details as Special United States Attorney in the Northern District of Illinois. Since 2015, I have served on the board that oversees Virginia and advises Virginia's Medicaid program, and currently serve as the chair of that board, have advised a number of state and national political campaigns on healthcare issues, including 2 presidential campaigns, and I'm a fellow of the American Health Law Association. Robert, why don't you introduce yourself?
Sure. I'm Robert Liles, and I'm the managing partner here at Liles Parker, and we appreciate the opportunity to talk to our friends with the Texas Association of Home Care and Hospice. I've been in healthcare for many, many years. I kind of refer to myself as a recovering hospital administrator. I have a master's in hospital administration, worked in the hospitals before I ever went to law school. I was a federal prosecutor out of the Southern District of Texas, and when HIPAA was passed in '96, I was selected to be the nation's first healthcare fraud coordinator for all the U.S. attorney's offices in the country. Since going into private practice, I have represented home health, hospice, and personal care companies in audits and government investigations, including, of course, matters involving alleged violations of the anti-kickback statute and Stark.
Robert and I are going to be discussing some dramatic new changes to the anti-kickback fraud and abuse rules that the Office of the Inspector General published in late December 2020 and that became effective on July 19th of this year. These revisions established 7 new safe harbors and revised several of the existing safe harbors, and they're probably the most dramatic change since the safe harbors were first implemented. As you're all aware, the healthcare system has been moving to more value-based payment mechanisms that reward the value, quality, and cost-effectiveness of treatment rather than the volume of care. And these include payment mechanisms such as the Medicare Shared Savings Program, a lot of people call that the Accountable Care Organizations Program, bundled payment arrangements, and a whole host of pilot projects generated out of the Center for Medicare and Medicaid Innovation, or CMMI. They also focus on providers taking varying degrees of risk and care coordination among these providers, and the mechanisms are only expected to increase in the future. These payment mechanisms frequently turn the risk factors and incentives that exist in the old fee-for-service payment model on their head. Instead of worrying about artificially and improperly increased Medicare volume, they are frequently and more akin to those existing in a managed care model, namely the concern over stinting of care. For these reasons, and to avoid creating mechanisms that disincentivize where the system wants to go, the OIG developed these new safe harbors to make them conform to the value payment-based payment models. At the same time, CMS published a companion regulation revising Stark that, while not identical in all respects to the changes in the anti-kickback rules, also create new exceptions to Stark to conform these value-based models of care, to conform to these value-based models of care. Because of the extensiveness of the changes, we've separated the two sets of changes and hope to do into two separate programs, and hope to do another separate program on Stark changes in the near future. I do want to emphasize that while the revised rules and new safe harbors provide additional flexibility, they also are highly technical. And as before, while a program that does not fit exactly into the new safe harbors is not necessarily the type of conduct that the government would prosecute, they're highly technical, and these arrangements need to be examined with your counsel to make sure that they are either in compliance with the safe harbors or are structured to minimize risk of civil penalties and criminal prosecution. Robert, shall we go to the next slide? Robert, why don't you tell us a bit about
before we
that?
kind of get into the changes to the safe harbors, let's talk about the basics, okay, Mike? I mean,
Sounds good to me.
An anti-kickback violation, the anti-kickback statute, is a criminal statute that prohibits the knowing and willful payment of remuneration, which is a crazy word that means anything of value, to induce patient referrals, okay? So let's kind of look at the statute kind of going back a little ways. This statute it's been around forever. It's been around since 1972. And I actually wanted to, I went back and pulled the language from the original passage from Public Law 92-603. You can see in here, when they first passed it, they didn't include the language knowing or willfully. It's really kind of interesting. And when they first passed it, of course, it was a misdemeanor. Okay. Now, it was modified in 1980 with the passage of the Omnibus Reconciliation Act of 1980, and that's where they first put in the phrases knowing and willful. Well, so what does that mean, knowing and willful? Most of us and most of the courts took the position that knowing meant actual knowledge and willful meant specific intent. The problem is not all the courts took that position. So there were a lot of disagreements across the country as to what exactly knowing and willful meant, okay? Let's go to the next slide real quick. That was really supposed to be cleaned up, if you will, with the passage of the Affordable Care Act. And under the Affordable Care Act, violations of this criminal statute, the anti-kickback statute, they made a couple changes under the Affordable Care Act that impacted. First of all, they said that knowing does not require actual knowledge, okay? And willful does not require specific intent. So essentially, they've taken this criminal statute, and it's now a felony, by the way. They made it a felony, I believe, going back all the way to 1980. But they've taken this criminal statute now, and they're saying that you can violate this criminal statute without actually knowing that you're doing it and without having the specific intent to do so. Now, that really bothers me, okay? They also made changes to the anti-kickback statute at that time, okay, to make it to where by statute, a violation of the criminal anti-kickback statute can also be pursued as a civil violation of the False Claims Act. So these are significant changes, but I do think it's important to kind of look at the evolution of the statute itself. And really, if you go back and look at the congressional record, when they first passed the statute, there were a lot of folks out there saying things that today would, I think, make it very clear that Congress never intended for the anti-kickback statute to be this broad. But the fact is, that's why we have safe harbors, isn't it, Michael? Because really, when you look at how broad the anti-kickback statute is, Congress said, you know what, we recognize that it's overly broad. So Congress sat down, and essentially what they did was they identified statutory safe harbors that they said, even though by law, certain conduct would probably violate the statute. Let's go to the next slide. We're going to set up certain statutory provisions that say that if you put certain safeguards in place, it's not going to be considered a violation of the law. Now, part of the reason we talked about the fact that the anti-kickback statute, it really has broadened over the years. If one purpose, there's something called the one purpose test under the Griever case, and the court held essentially that, you can have 3 or 4 different legitimate reasons for the conduct that you're doing, and those reasons could actually save the system money. They could they could improve patient care. But if one purpose of entering into that business arrangement is to induce referrals, okay, then it's a violation of the anti-kickback statute, okay? They've raised the fine to $100,000 now to result in exclusion. And you have to understand, Texas has been, the U.S. Attorney's offices in Texas have been extraordinarily aggressive in recent years when it comes to employing the criminal anti-kickback statute against home health and hospices. There are a couple cases here. This one that came out just last month, they've gone after an operations manager here of a chain of home health and hospices that they say that the operations manager was facilitating kickback payments to referring physicians. This is kind of one of the things I want to point out. I mean, it's so important that you have all of your business arrangements carefully reviewed by a qualified healthcare lawyer to make sure that the conduct that you're engaging in does not violate the anti-kickback statute. I used to tell people, and I still tell people, business practices, common marketing and business practices that may be perfectly legal in every other industry, it's not at all uncommon for them to be illegal in healthcare. Okay, there's another case out of the Northern District of Texas in March, and in this particular case, the owner of a hospice agency pled guilty to conspiracy to commit healthcare fraud. Now, they charged him in this case with conspiracy, okay? They did not charge him with the violation of the kickback statute, but if you actually look at the press release, what was he doing? Well, he was paying doctors $150 for false orders, okay? So, that just kind of shows you. I mean, you can't, and so, it's not just a matter of the initial referral, Michael, is it? It's also recertifications.
Absolutely.
So you've got to really be careful. Let's go to the next slide.
Yeah, and on this slide, basically, this slide demonstrates the legislative glide path from the beginning of value-based payments through the enactment of the Affordable Care Act and the establishment of the Medicare Shared Savings Program and also the Innovation Center. And through the establishment of the merit-based incentive payment system that revised how Medicare pays docs. Later this summer, my colleague Heidi Coker and I will be doing a separate seminar on value-based payments and alternative payment methodologies that will go into much greater detail on these programs. But the key is that you basically the safe harbors and the anti-kickback statute and the way that OIG historically has looked at it does not work for these alternative payment methodologies because there are different sets of incentives, namely providers accepting risk.
Now, when you say safe harbors, Mike, you mean the existing safe harbors before the issuance of these new?
Absolutely.
Okay, and so you're saying that's why they've issued some of these new value-based safe harbors.
That's one major reason. The other major reason was because the OIG, as we had started to move toward these payment systems, and those of you who have participated in the bundled payment initiative or in the shared savings program understand that the OIG issued a number of waivers because they realized that the current statute and the current safe harbors made no sense. So they're trying to move a lot of the features of those waivers now into the new safe harbors. And I would also mention that you have a number of private insurers moving to value-based payment systems and even to systems where providers take full risk for their patients. And I recommend to you something called the Learning Action Network that's run out of Duke University and by the former CMS Administrator Mark McClellan, if you're interested in viewing some of these more aggressive payment systems that I think you're going to see in the future. Can we go to the next slide, Hunter, if we could? This slide discusses what's referred to as the regulatory sprint to coordinated care. It reflects the terminology developed around 2018, where HHS began the process of removing what it considered regulatory barriers to this coordinated care. And the anti-kickback and Stark revisions are the most recent government actions in the area. The slide also reflects the fact that while OIG and CMS work closely together on these rules, there are some differences. As the slide mentions, given that Stark is a strict liability statute, CMS provided more leeway in a number of its exceptions than OIG did in its safe harbors. And these differences can result in an arrangement complying with the Stark exception, but also being outside of the safe harbors.
Now, Mike, I got a question for you. You know, when the current administration came in, one of the first things they did, understandably, is they put basically a freeze on all the regulatory actions that were kind of in the system at the time. And they also, you know, stopped a lot of the things that were ongoing. I do think it's notable, it's worth mentioning, that this regulatory sprint, you know, was brought under the Trump administration, and this is not something that the administration, you know, stopped, you know, or said, hey, let's slow down or anything. So that says a lot to me, because there aren't really a whole lot of initiatives that the current administration really adopted so readily.
Yeah, that's an excellent point, Robert. Now one of the reasons was that it had become the effective date had occurred one day before the inauguration.
But he still could have stopped it.
They can what they can redo if they wish to stop it is immediately publish a pause or new proposed regulations.
That's right.
But it's a great point that they have not. This is one area where they have not done so.
And I give them accolades for that, you know, because this is something that needed to be done. And I think regardless of which side of the aisle you're on, you realize this was a problem.
Yeah, but the difference is also between Stark and the anti-kickback provisions also further reinforce the need that you're going to need counsel if you're going if you're entering into these.
Oh, that's and Mike, let me just kind of follow up on that. That's a really important point that you just made, and that is this is more complicated than ever.
Yeah, as you will see.
You know, it's the kind of thing where, you know, before you try to make a business or set up a business arrangement that you believe is going to qualify for coverage under one of these safe harbors, you really need to get qualified counsel to look at that and advise you.
And I'm sure that those of you who have been part of BPCI or the Shared Savings Program have done that to date, but this is even more, or the Comprehensive Joint Replacement Program if you were collaborators, but now it becomes even more important to do so. Can we go to the next slide, Hunter, if we could? Yeah, this slide simply lists the new safe harbors that have been promulgated under the new rules. And we'll also be discussing additional changes to 4 existing safe harbors that aren't on this list at the end of this presentation. But as you can expect, the rules become more flexible based upon the amount of risk that providers participating within the arrangement take. Hunter, can you go to the next slide?
But before we go to the next slide, I think it's noteworthy, you know, the fact that there are now 11 statutory and at least 36, it depends on how you add these things up, 36 regulatory safe harbors is just unbelievable. I mean, you know, they add 2 here and 4 here and 3 here, and the next thing you know, we've got 47 different safe harbors under the anti-kickback statute.
And the reason for that, as you pointed out early on, is because the statute's so broad that it's got to evolve with additional safe harbors in order for the program to be able for the program to be able to function.
It's extraordinarily broad. We cover so much.
Yeah. Can we go to the next slide if we can, Hunter? The next three slides provide several definitions that are really essential to the three value-based safe harbors that we're going to discuss. Care coordination arrangements, value-based arrangements with substantial financial risk, and value-based arrangements with full financial risks. And the definitions are, again, quite complex and wordy. We have a slide that tries to simplify it, but again, you need to make sure that you're fully that your arrangements fully comply with them. Now, the first one describes basically the arrangement as two or more participants that collaborate to achieve at least one value-based purpose, are each a party to a value-based arrangement with the other, or at least one other participant that is a part of the same value-based and enterprise that has an accountable party or person responsible for financial and operational oversight of the enterprise, and has a governing document that describes the enterprise and how the participants intend to achieve the purpose. And these can vary greatly. Examples could be anything from a separate legal entity, such as an accountable care organization, a large network of providers, or simply two or more providers contracting together for a value-based purpose. Hunter, can we go to the next slide if we could? A value-based arrangement is an arrangement between a value-based enterprise and its participants, or among the value-based enterprise participants in the same value-based enterprise for a target population. And that concept of target population is really an important one for these safe harbors. You can't just be going out willy-nilly. You have to have the arrangements have to be focused on a particular group of patients. For example, ones that have an example of an existing type of arrangement is the Comprehensive Joint Replacement Program, which focuses on patients who have had knee or hip replacements. That would be and have had surgery for that. That would be an example of a target population. And a value-based participant is an individual or entity that engages in at least one value-based activity as part of a value-based enterprise. However, there are a number of types of entities that are excluded from being participants. And these are basically types of entities that are in the supply chain. As we've got listed up there, they're compounding pharmacies, pharmacy benefit managers, pharmaceutical managers, distributors, wholesalers, lab companies, durable medical equipment suppliers, other than a pharmacy or a physician provider or other entity that primarily furnishes service, and where this is just, the DMEPOs are just an ancillary part of the business, and medical device distributors and wholesalers. And again, there is, however, even here, a limited set of circumstances where a DMEPOs or a manufacturer of devices or medical supplies can achieve safe harbor protection of certain digital technology arrangements under the care coordination safe harbor, which we're going to discuss in a minute. Hunter, can we go to the next slide if we could? Oh, wait a second, move back there, I apologize. A value-based purpose, on the other hand, is one or more of the activities listed in the definition for a specific target population, namely coordinating or managing care for the target population, improving the quality of care, reducing costs or growth expenditures for payers where you don't reduce quality, transitioning from volume-based delivery and payment mechanisms to mechanisms based on quality and control of costs. Can we go to the next slide, if we could, Robert? Next slide, please. We're having a little technical difficulty here for the moment.
Excellent.
I apologize, we're having a slight technology issue here. The slides.
No, the other direction.
The other direction.
There you go.
There we go. Okay. This slide, for all the complex verbiage that we did, my partner, Mr. Liles here, decided he'd try and put it in English for us. So the slide, wait a second, we have to go back one more slide. I apologize. This slide just contains definitions of value-based activity and target patient population. And as I said earlier, the target population is a really important concept. Next slide, if we can, Hunter. Now we're at the place where we try to make this a fairly simple, try to simplify this to some degree. And basically, as it mentions, you have a value-based enterprise that has two or more participants, which are provider groups. They collaborate to achieve at least one value-based purpose, participate in a value-based arrangement, and engage in value-based activity intended to achieve identified value-based purposes for a target population. It's an excellent slide, but again, it points out to the complexity of the whole process. Next slide, please, Hunter. And this is just a slide that was prepared by the OIG separately from the regulations. I want to focus that sets out who can participate where in these particular new arrangements. But I want to make safe harbors, but I want to point you to the disclaimer, which tries to make it clear that to the extent that the chart differs from the regulations, worry about the regulations. In other words, it's a nice cheat sheet, but you have to go through the regs. Any rate, next slide. Here we've got, okay, we're going to go through now each of the safe harbors. The first three are what we call the new value-based safe harbors. And the first one that we're going to discuss is the new safe harbor on care coordination arrangements to improve quality health outcomes and efficiency. The safe harbor protects arrangements that meet conditions where participants do not meet the risk requirements for the other two value-based arrangements. Namely, they don't necessarily have to require any risk. And as this slide sets out some of the conditions, the most important is it's used primarily to engage in value-based activities that are directly connected to the coordination management of care for target population and does not result in more than incidental benefits to persons outside of that population. But there are basically several key points. You can read at your leisure the slide, but the key points you need to remember here are it's in-kind remuneration and not cash. If you're not taking risk, the recipient of that cash, in-kind remuneration, namely, for example, home health agency that gets some kind of equipment or assistance from somebody else, has to pay 15% of either the offeror's cost or the fair market value of that product. The arrangement needs to be set forth in a complex agreement that contains specific components including the target population to be served, the specific outcome and the specific outcome measures that the parties are going to use to measure whether you're to measure success. An example of this type of arrangement that might fall under the safe harbor would be one where a hospital and a physician group engage in a care coordination arrangement where the hospital provides the physician group with a care manager for post-discharge care and also potentially provides remote monitoring technology to alert the physician group when a patient needs care to prevent unnecessary emergency room or visits or hospital readmissions, and you can substitute home health agency for the for the physician group in there as well. Also, unlike the other two value-based safe harbors, this safe harbor allows for participation of medical device and supply manufacturers and durable medical equipment suppliers under the limited digital health technology exception. Can we go to the next slide, Hunter, if we could?
Also, someone asked a question. You will all be receiving the slides at the end of the presentation or later on. So any attendees, I just want to let you know.
Yep, absolutely. Now, this slide discusses the requirements of the second value-based safe harbor, namely where the value-based enterprise and one or more of the participants meaningfully share in a substantial downside risk that the enterprise assumes from a payer. You can read again the requirements here, but I want to point out several key points here. First of all, the remuneration can be in kind or in monetary payments. There's no limited exception for durable medical equipment suppliers or medical suppliers and device manufacturers to be able to participate. There are 3 different methodologies, pretty complex, that are listed in the regulations for determining both whether there is substantial downside financial risk and also defining the meaningful share that the participants need to take. The arrangement has to be directed toward a defined target population and one or more value-based purposes, and can't take into account referrals outside the target population. Payments cannot be an offer of an ownership or investment interest, and there are limits on using payments for marketing or patient recruitment. You need a carefully crafted written agreement. Any of you folks who are collaborators in something like the Comprehensive Joint Replacement Program are familiar with how complex these arrangements can be. It's got to be for at least a year, and it can't restrict the participants' ability to make decisions in the best interests of patients. And you've seen that a lot of these, again, in all of your alternative payment methodologies. Next slide, Hunter, if you would. This slide talks about the third value-based safe harbor, and it protects certain arrangements where the value-based entity or participant on behalf of the VBE accepts full financial risk for each payment in the target population, namely capitation. The key points here are, like the safe harbor, where the VBE accepts substantial risk. The payments can be in kind or in monetary. There's no limited exception, again, for DME providers or medical supply companies. There is a specific written contract. There's a need for a specific written contract for at least a year. Any shared remuneration must be related directly to the value-based purpose, and it can't induce the reduction or limitation of medically necessary services, and it can't take into account the volume or value or condition of referrals of patients outside the target arrangements. And the key to the safe harbor is that the more risk that the value-based enterprise or its participants are willing to take, the greater there is of the flexibility, because basically the acceptance of risk provides a level of protection against overutilization, and again, shifts the focus to ensuring that there's no stinting of care. The next slide, if we could. We're going to try and move a little quickly here, but the next safe harbor is one that is related to the value-based arrangement safe harbors, namely arrangements for patient engagement and support to improve health outcomes and efficiency. And basically, it's available not for cash, but for a patient engagement tool or support furnished by the value-based enterprise to a participant to a patient in the target population. The key points here are, again, the safe harbor covers only in-kind remuneration with a value of $500 or less annually, and that has a direct connection to the coordination and management of the target population. The tool or support must be furnished directly to the patient or caregiver and only on behalf of the patient. And the tool or support must be recommended by the patient's licensed healthcare professional and meet one of these 5 goals: either adherence to a treatment regimen, adherence to a drug regimen, adherence to a follow-up care plan, prevention or management of a disease or condition, or patient safety. and the support tool can't be funded by a patient or person or entity that is not a participant in the VBE. It can't take into account the type of insurance that the patient has, and that's because they want to avoid cherry picking. And it can't be used to market other reimbursable items or to recruit patients. And an example here would be the provision of certain digital technology to monitor the patient if the other requirements are met. Next slide, Hunter. The next safe harbor is an obvious one, namely what is referred to as the CMS sponsored model arrangements and CMS sponsored patient incentives. These are defined as models sponsored by the Innovation Center and the Medicare Shared Savings Program, and they can take such forms as distribution of capitated payments, shared savings or losses distribution, or incentives. And those of you who've participated under models such as BPCI, the Medicare Shared Savings Program, and the Comprehensive Joint Replacement Program are familiar with the rigors and waivers that are part of these programs. And in fact, you see a number of these features of these programs in the new safe harbors. OIG did this because they've got experience with these programs, and they've recognized that the Innovation Center and CMS have built in significant protections in the models and have experience in understanding how to protect against bad conduct while not frustrating the very purposes that these models are trying to achieve. And it also avoids the necessity of the OIG having to issue future waivers for each model, of which it's really less knowledgeable than the entity that's developing these models. So they're very comfortable in this particular area. Now, there are additional parameters that you're going to have to meet. And again, those are listed up there. They're fairly simple ones. You can't result in overutilization, reduction of medically necessary care. You don't want to induce referrals of patients outside the model. And most importantly, CMS has to affirmatively state that the parameters that state that the model falls within this safe harbor. Robert, now that I've bored the world with and confused the world.
Feel free to keep going, Michael. I think that you did a great job on those, I'll tell you. And we're going to come back to you in just a second on the ACO safe harbor. Is there a question, Hunter?
Oh, no.
Okay. All right. So the next one we're talking about, of course, is cybersecurity, technology, and related services. And it's really meant to cover certain donations of cybersecurity technology. Once again, you know, the term remuneration. Let me just say this: remuneration never allows you, okay, to give money. Okay, I mean it's
under the safe harbor.
That's right, and it can't take into account the volume. Does that include? Nor can it consist of cybersecurity technology and services. Okay, that you can't take into account the value or volume of referrals. You can't make neither the recipient or the recipient's practice can make the receipt of the technology a condition for doing business with the donor. You know, a lot of basics here, I think, that are going to kind of come into play. Let's go to the next one, the ACO, and that's really Mike's one of the few folks that really has a lot of experience with these things, Mike.
Yeah, but let me back up a little bit on cybersecurity,
sure,
if I can, which is that one of the things that they've recognized here, this points you to the focus of the concern of OIG and frankly CMS also on the problems of cybersecurity, and because of that, there's a certain degree of flexibility for a provider, for one of the entities in the VBE or the VBE itself to donate cybersecurity technology, or anyone, frankly, anyone to donate cybersecurity technology, for example, to physicians or to, or for that matter, to home health agencies. It's absolutely a critical area for us. Let me go now to, give me 1 second here. this safe harbor, this particular safe harbor is what they call the ACO Beneficiary Incentive Program. This one's in statute, and basically, and home health agencies and hospices aren't really a part of this. This enables a payment of $20 for the utilization of primary care services and services furnished by rural health centers, and it's basically to incentivize both participation of patients in the shared savings programs and by Congress, and also, frankly, to encourage patients to utilize primary care services and to make sure that, and not to stint on getting them, to make sure that they maintain their wellness.
You know, this is one of the ones that I think is a little confusing, just because it's listed among the regulatory safe harbors. But as you pointed out, and I think the first thing you said, it was really the result of congressional action. So it really is a statutory safe harbor, but it, you know, once OIG got around to finally doing something about it, they listed it as a regulatory safe harbor. So that's why it's kind of hard sometimes to figure out what silo they go in.
Yep, but the important thing is that you've got to fall within. You've got to fall within that particular safe harbor. Just make sure, whether it's statutory or regulatory, that you either meet the safe harbor or you've discussed with counsel.
Yeah.
Minimizing the risk, because again, remember, the fact that you don't fall within a specific safe harbor and meet every jot and tittle does not necessarily mean that that it's illegal. That the OIG will find it as conduct that it wants to, or DOJ that it wants to, that would prosecute. But certainly, it is best to fall within the safe harbors. The next several, Robert's going to take the lead on.
Okay, the modifications to the existing safe harbor, and this is one really that home health agencies are knee deep in, and that is there were changes. The personal services management contract safe harbor, okay, was modified, and prior to the issuance of this final rule, you know, it was really difficult to meet the requirements under the personal services and management contract safe harbor, because it required that aggregate compensation had to be set in advance. Well, that just doesn't work if you've got part-time people or you've got per diem people that just come in and you're paying them on a daily basis. How, you know, with part-time especially if it's part-time as needed, you know, there was no way for you to know in advance, a year in advance, how much time you're going to. So they modified it. And under the final rule, you no longer have to know the aggregate compensation, but you do have to establish the methodology for determining compensation in advance. But before you get too excited, they left in place a couple of the fundamental requirements that make it difficult. For instance, let's say you've got marketing people out there and you want to pay them, okay? Well, you know, this makes it very clear still that the statute says you can't base their compensation, okay, on a manner that takes into account the value or volume of referrals, okay? You can pay them by the hour, and it can be an indeterminate amount of hours that you're expecting, okay? But, you know, what they're getting paid really can't be driven by the value or volume of business, okay? Now, also, you have to have it in writing. It's got to be set in advance. It's got to be consistent with fair market value. And you know, there are several other minor requirements. But the point, though, here is that for the first time now, it is possible to at least employ people on a part-time basis, typically hourly or on a per diem basis. And as long as you fit within these requirements, that business arrangement, if you will, and we're not talking about employees, okay? This is not for employees. I mean, you still have the employee safe harbor that is a lot more forgiving if it's a bona fide employee, okay? But for non-employees, you know, that you're trying to use, the personal services management contract safe harbor has been modified so it's easier for you to qualify, okay, with your independent contractor types.
And that's the most important first part of the change is the fact that we moved from necessarily setting forth
That aggregate compensation.
the aggregate compensation and the intervals and the specific intervals so that you can use them as needed to setting forth the methodology instead. Next slide.
One of the people, let me ask you this, Michael, one of the folks has said, how do you recommend an employee be paid, salary or quota? Well, now we're talking about something different. Remember, this slide it doesn't cover employees. This slide covers independent contractors. With employees, the first thing you have to do is you have to be able to show that it is a bona fide employee, okay? So definitely get your attorney involved in that evaluation. Now, I don't have the employee safe harbor in front of me, but I can tell you that if it is a bona fide employee, you have a lot of latitude, and you can bonus them based on success.
Yeah, but there's a caveat to everything in this world, and the caveat is that the OIG is starting to take a look at, rightly or wrongly, they're starting to take a look at even, for example, percentage arrangements and quotas under the employee exception. So you want to make absolutely certain that.
Well, they're attacking whether or not someone's a bona fide employee. That's how they're doing it.
Yeah. And
but the answer to your question though, what do I like? I like a salary. Okay, yeah. I like a straight salary. At the end of the year, you can bonus your staff based on overall performance of the organization. It's not tied to referrals. And I like a salary because, and you tell your folks, I expect you to work and work hard. And if you're not doing what you're expected to do, then we're going to have to let you go. But I prefer salary because you don't get into all these other headaches.
And preaching to the choir, Mr. Liles, preaching to the choir.
But this is probably the most important modification out of everything we've talked about today. When it comes to home health, this is the one that you need to be focused on.
You want to go to the next slide?
Yep.
This is the second part of the modification of personal services.
Yep.
And it basically takes into account outcome-based payments if certain requirements are met. Now, one of the toughest things to deal with on this one will be the written agreement setting out all the requirements.
And how would this work with home health? I mean, it's not going to work with marketing people, but I suppose it could work if you had
Absolutely.
Independent contractor nursing staff or someone like that, perhaps. I don't know. How would this work?
Or it could work if you had, for example, you were retaining an independent contractor to perform certain kinds of services, and you wanted to be able to bonus them or base their compensation on the outcomes that occur. An example would be clinical outcomes. Are they getting better clinical outcomes? And if they are, then then you'll fit within the particular safe harbor. So you haven't set forth.
So maybe length of stay even.
Reduction of length of stay. That's a great example. If a home health agency is able to reduce length of stay, you might be able to fit that within the personal services and management contracts area where you might not be able to fit it into one of the other safe harbors.
That way you could bonus your clinical people if they're able to possibly get people back on their feet and off service.
Yeah. So you're reducing. So you're basically getting better clinical outcomes. You're not doing it for volume's sake. You're doing it because they're doing a great job.
Exactly.
And they're helping.
Exactly. And that's this is really interesting to me because it is an existing safe harbor. It was modified, but they threw in this value-based, if you will, component into it to kind of encourage providers to figure out ways to improve quality of care.
And remember, we're moving to outcome-based. We're trying to move to outcome-based rather than volume-based care.
Right. Okay. Next slide. Warranties. Okay. Well, this is another modification, and it removes the safe harbor to protect warranties covering services. Okay, but it's really kind of weird. You can't have a warranty that only covers services, but if you have a warranty that covers, I guess, the product and the associated service, that's okay, right?
Yeah.
That's the way I read it.
Yep, and it also allows bundles, covering bundles of service, warranties and bundles of service.
How is that going to come in? Is that going to come in again with your hip example? I don't know. We don't know. We don't know how it's going to come in. This is so new. We don't know, but we're going to be monitoring it to see. Okay, next slide.
And you want to make sure you hit every. You want to make sure you hit every element of the safe harbor.
Right. Okay, local transportation. You know, local transportation has been a hotbed for many, many, many years. And frankly, there have been a lot of folks over the years that have been prosecuted for providing transportation. They finally loosened up a little bit on local transportation, and now they've loosened up again. Okay, and when I say loosened up, you know, I mean, the fact was that they finally issued a safe harbor for local transportation. But they've had all those restrictions on it. Now they've opened it up. If you're in a rural area now, if you meet certain requirements, you can provide local transportation for up to 75 miles.
And the other thing that it allows is unlimited miles to a patient's home. And the goal here again is we've all started to recognize the importance of transportation of patients to be able to get care. It's especially important in the Medicaid program, for example, where folks may not, and in rural areas where you don't necessarily have access to transportation.
And that's very prevalent in Texas, a lot of areas.
Or in poorer areas where you need to get to your provider, and you may or may not have an automobile. And you're starting to see, by the way, and that's part of the reason that they expanded the distance locations here. You're also starting to see joint ventures, for example, between providers where Uber, pre-COVID, where they were starting to use Uber, and as we come out of COVID, we're going to see a great deal more use of ventures where free transportation is part of it.
Okay. All right. Next slide. No, that's.
They modified slightly the EHR, the electronic health records, safe harbor, so that you can, so that they removed the sunset provision. They removed a no equivalent technology provision, and they expanded the type of EHR replacement services. This has been a safe harbor for a while, but they expanded it to allow now replacement services. They've still kept into the requirement, however, that the recipients still pay 15% of the donor's cost for the EHR items and services. And you want to check very carefully as to whether the particular item or service fits within the safe harbor. Cybersecurity, by the way, can also fit in here, but there are additional requirements here that aren't in the cybersecurity safe harbor. I have to close it here. And Robert?
Now, Mike, this is kind of an interesting one to me. I mean, this is something that technically it's really kind of a new statutory exception to the CMP laws. I mean, so you know, if you look up the statutory safe harbors and the regulatory safe harbors, you're not going to find this. You have to actually go to the CMP laws to actually find this. So that's why I put the citation up there. But telehealth for in-home dialysis. And it's, this is a new statutory exception to the beneficiary inducements CMP. And under this new statutory exception, what they essentially said was the term remuneration, which of course means anything of value, does not, by statute, include the provision of telehealth technologies to folks with end-stage renal disease by a provider of these services, okay, when they're providing, telehealth and in-home dialysis, so that's really a significant change. Now, it can't be part of any kind of advertisement or solicitation, and the telehealth technologies have to be provided for the purpose of furnishing telehealth services related to the individual's end-stage renal disease.
And go ahead. Do we have any questions, Hunter? I have a close, if not, that I'd like to mention.
I have not gotten any other questions other than
The ones
we've gone over.
Great.
Okay, well, in closing, I want to just emphasize a couple of points. A particular arrangement may fit into more than one of these safe harbors, or it may appear to miss fitting into one on a technical basis, but actually fit into another. As the OIG points out in all of this, an arrangement simply needs to meet one of the safe harbors to be protected. They interlock in a number of places. Also, as with all arrangements, we keep pounding on this. The fact that an arrangement doesn't fit squarely within all the conditions of a safe harbor doesn't mean that that the OIG, that the arrangement will be questioned or prosecuted. It simply means that the OIG is not granting blanket protection from sanctions. A legal counsel can assist you to fit wholly into one of the safe harbors, minimize the risk that a venture might create, and also there's an advisory opinion vehicle available for protecting the arrangement. And again, legal counsel can help you prepare the request. And finally, we want to emphasize that while we went over these rules, we couldn't possibly cover every requirement in a 1-hour period. They're highly complex. Their application can vary based upon the arrangement. In some respects, some of them are very new, and you should make sure that you review any of these relationships that you enter into in the future with your legal client, with your legal counsel.
Mike, the only thing I would add is that even if you have a business arrangement, and I believe you kind of alluded to this in the very beginning, even if you have a business arrangement that appears to meet one of the anti-kickback statute safe harbors, that doesn't relieve you of your responsibility to do a completely separate analysis under Stark and a separate analysis under the False Claims Act to make sure that, in fact, you're okay. You got to run all the tracks. Okay, you can't look at either a Stark exception or an anti-kickback safe harbor and say, well, that meets it, so it must be legal. Unfortunately, it's a lot of moving pieces, and you got to meet them all.
That's a great point, Robert. We want to thank you. This may be the first one that I ever finished 2 or 3 minutes early. If there are any questions, we'll just wait on the line for just a couple of minutes.
I just asked everyone in the audience if they have any questions. Ask them now. So
yeah, please ask them now. Also, you can call either Robert or me for a free consultation if you have existing questions as we go along.
I'm asking you, please, if you have a question about value added, don't call me.
Value-based.
Value-based. Call Michael.
I think look, this is where the horse is going. And as I mentioned, if you take a look at the Learning Action Network, they even are pushing folks to move further and further to full risk along they have what they call a 4-quadrant risk continuum. It's what we're going to see in the future. It's where the opportunity is going to lie especially for home health agencies, to be collaborators with hospitals and with hospital systems, since you are now probably one of the most important parts of the system, and personal care is becoming a bigger and bigger issue. For example, Medicare Advantage now allows supplemental payments to be used for things like personal care. And on the Medicaid side, you're seeing a lot greater emphasis on the social determinants of healthcare. So, with that, we thank you for your attention, and thank you for giving us this opportunity.
Thank you so much for joining us. Have a wonderful day.